Alright, so for your for the lunchtime presentation, we wanted to bring you a couple of our own reporters. Angela Chambers with the 395th District Court, and Amy Walker with the 277th District Court. They're going to talk to you today about evidence and kind of working with your court reporter in hearings and trials, and hopefully you're going to learn some things, especially...
Okay, it's not down.
Okay. So hopefully you're going to learn about where your exhibits go and what happens with them, especially after the proceeding. And so without further ado, I will hand the microphone.
So I invited Angela to come speak with us because of a mistake I made in court. And those of you who were upstairs in the family part of this already heard this. So I apologize for you hearing it twice. But I did something very, very foolish that created a lot of work for Ms. Chambers, and I did not intend to do that. The situation was there was an opposing party who was pro se, and he was recording. He purchased a bunch of recorders from the Spy store, and they looked just like a flash drive. They looked exactly like a flash drive, and he had planted them all over the house and all over the car and all these places. So my client had gathered them all up, and I had them in a sack. And I had them sitting on counsel table. And I moved to admit, because I wanted the judge not to see the content as to one of these. I just picked up a random one. I wanted the judge to hold it in his hand and feel it and see that it looks just like a flash drive. It's undetectable, except for this little tiny switch on the side. So I said, I'm not, and I've repeated it several times, I'm not admitting this as to content, I'm admitting it as to the object itself only. Well, I didn't realize by doing that I had created a hornet's nest for Angela. Because, of course, the other side started screaming and yelling. It went up on appeal, and the other side screaming and yelling that they're entitled to content of what's on that flash drive. And being a pro se, there's great latitude given, and everybody knows that. Well, it was foolish. What I should have done is I should have taken lots of up-close pictures and admitted those pictures instead of the actual object. Because I didn't realize at the time, until I heard from Ms. Chambers, the hassle that is for her when she's got to physically carry that evidence down to the Court of Appeals and check it in on her own time and how all that works. So I made a colossal mistake, and I don't want to make any more. And so I invited our court reporters today to come visit with us. They've both been doing this for many, many years. Angela did it in Travis for, 20 years plus? And now she's up in Judge Larson's court, and Amy here is in the 277th. This is her home court. So I've invited them to come talk to you so that you guys won't make the same mistake and headaches for these ladies that I did. So thank you guys for being here.
Hello everyone. Can everybody hear me okay? Am I loud enough? Yeah? Okay. Well, as she said, my name is Angela Chambers, and if I haven't had the pleasure of meeting you, hopefully that I will. I am the official court reporter in the 395th District Court. I am kind of the new kid on the block, though, here in Williamson County. I've only been here for a couple of years, and so I asked our senior district reporter to come and help me because there are a little bit of differences in the way that Williamson County handles things versus Travis, and so because of the size of our counties and different things like that. So I just wanted to, I thought it might be helpful to have a perspective from not only a family court, which we handle family, civil, and CPS, and Amy does felony, criminal, and juvenile. Okay. I feel like some of you guys are looking at me like, oh my gosh, they talk. Who knew? We will admit to you that we're a little bit nervous because we don't normally speak in front of people. We are usually seen and hopefully not heard. If you're hearing from the court reporter, not good for you. I'm just going to say. But yes, so I have been a reporter for 28 years. Amy has been reporting almost that long as well. We both started out freelancing, doing depositions and public hearings. Then we both worked in county courts. You can say what you've done.
No, I started out subbing in my county courts and district courts before I actually became an official.
And I've actually worked in a county court for a little while, and then I worked in several district courts in Travis and then obviously now. But between us, we have 50 years experience just about, and so hopefully we can impart some good stuff with you today. But I will say, you know, even though I've only been here a short time, I haven't got to know all the reporters, but the ones that I have gotten to know, I need to tell you all, you are very, very lucky. You can have confidence, because the ones that I do know are very conscientious, they strive for perfection, and so you can rest assured and have that confidence that they are making a very good record for you and trying their best, okay? So let's move on to exhibits. That's what we're here to talk about. Your supporting evidence, your documents, your CDs, just all the myriad of evidence that comes in. Okay, I just want to make sure. Slide 2. And, you know, sometimes we wonder, does anybody ever care? I've been spending the last hour deciding whether a semicolon should go here versus a period. But obviously you guys are here and you must care about your records, so you should be commended for that. We have all heard about the 7 habits, say that 10 times, of successful people. And one of those is beginning with the end in mind. And I have to say that is really what you all do all the time when you come to court with your case law prepared. You're thinking about winning your case. We, too, are thinking about that. We're more thinking about the one that loses, quite frankly, because we're thinking about the appeal and how we are going to make this most readable and understandable for a higher court. We have to do this when we're thinking about our notes for misdemeanors and civil cases. We keep our notes for up to 3 years. For our felony cases, we keep it 15. For our death penalty cases, it literally is until death do us part. So we think about this when we are marking our exhibits. So, you know, in depositions, it has its own challenges. We've got a group of lawyers in a room with no referee. But as it relates to exhibits, it's easy enough. We just have we mark it with the witness's name or just the deposition exhibit for those of you who do depos. In criminal court, again, easy enough. We always know who represents the state, who represents the defense. And so that doesn't get too complicated. But then I show up to family court, and I sit down. It was my first time to work in family court as an official, and there is just this, you know, smorgasbord of exhibits. Yes. We've got employments, petitioners, respondents, plaintiffs, defendants, movements, applicants, attorney ad litem, respondent mother, respondent father, courts exhibit, and so, you know, unlike some of the judges who know everything about your file before you get there, the court reporter does not necessarily know that, okay? So I can deduce from my docket that one of you are the petitioner, one is the respondent, but then, lo and behold, that day, you're not the respondent, you're the movement. And we're not going to know that ahead of time. And so unless when you announce yourself for the record and you say that, there is no way for us to know that. So we are likely to mismark. So show a little grace, whisper, hey, today I'm the movement, or, you know, today I'm the respondent. So because we're not going to know that otherwise unless you let us know. And especially for our substitutes, listen, this is, it is hard to take off because everybody's terrified of court. And there is a shortage anyway. But anyway, so just extend a little grace and help us out when it comes to knowing what your role is for that particular day so that we can mark your exhibits appropriately. I am so thankful when someone asks me, how do you want to mark your exhibits? You know, whether it's pre-marking or mark as you go, or I've had lawyers, hey, you want to just hand me a pack of exhibit stickers? And I'll just do them as I, do them as I want to do them. Well, the problem is, and that's fine if a reporter chooses to do that, that's her call, or his. But we have to account for that way down the road. So, in 3 years, if you decide that you wanted to mark 20 things, and you tell me, hey, I've marked 20 exhibits, but you didn't use exhibit number 3, like you just didn't use it, it became irrelevant. I'm not going to remember in 3 years, or when I'm going to the clerk's office, oh my gosh, what happened to exhibit number 3? Did I lose it? I'm freaking out. So I like to do it as I go, but ask your court reporter that is in that court how she would like to handle that. I'm just going to say she, because most of, except for Tom. Ask them how they would like to mark those exhibits, because what makes sense to me in the way that I like to mark the exhibits, we're basically the same, but maybe a little bit different for Amy. We're not even going to remember by the end of the day. I've already had 9 hearings this morning. I'm not going to remember what happened to those. But thinking with the end in mind, we have to make notes. I just can't even tell you guys everything that goes into it when you have to retrieve and prepare a document that 10 years from now that has to show just like it happened yesterday. And so we really have to put a lot of thought into that part of it. So when we're thinking with the end in mind, we think about where to mark them. And I know this is old hat for most of us, but it's just a good refresher. Personally, I like it on the front of the document. I don't want to remember, did I hit duplex on the scanner? I want it to be on the front and a place that's not going to be covering up anything. It just makes it a little bit easier. Depending on the case, like you have your SANE kits in criminal court, sometimes what is in the box is just as important as the chain of custody that's on the outside. So we may mark the outside of the box as Exhibit 1, but its contents and what goes with that box as 1A or 1B, etc. Because that may be they may never open it, and 1 is fine, okay? But if they have to go into more detail, then that's when we need to figure out a way to kind of keep those together. And always use numbers. You're never going to run out of numbers. CDs. Most of the time, you guys hand us CDs that are just in a little slipcover. That's not so important. But if somewhere in my office that cover, if the cover's marked and not the actual CD, I need to know where that goes. So please have your reporter, if it's a sub, most of us will mark the actual CD, but you want the actual CD to be marked.
If you put a sticker on the CD, is that a problem for the CD later?
It is a problem, yeah. So we use Sharpies for that. We can write on them. That's what works best for that. Original photographs. The other day I had somebody came in and they had this beautiful album that they had made from Shutterfly of a book with all their family photos to show how what a great family unit they are. Well, that's awesome, but you're never going to get that book back, number 1. And number 2, that doesn't go through my scanner. And the Court of Appeals has made it such that we have to have everything is digital. So you may want to think about that when you're thinking about how you want to prepare your evidence. Just in case you do need to appeal, you want to make sure that it's in a format that we can actually use. Copiers are not as common these days, so we have to figure out a way, whether it's taking a picture and then we upload it. It just gets really complicated. Voluminous exhibits. Oh my goodness. Okay, I'm just going to tell a little story. So we all have life experiences, and so most of our mistakes are how we learn and we become better. I had a case in Travis County, and nobody called me ahead of time. It is, you know, day 2, we've already had more dire, the door's open, and in comes dollies of boxes. And I'm just thinking to myself, oh my gosh. Number one, my vault isn't that big. What am I going to do? Maybe they're just going to pull pieces of paper from them, from those boxes. None of it was bait stamped. None of it was bait stamped. They would, because they have lived this case, and so they know to go to box number 2, file this piece of paper, and talk about it, and then put it back. And I'll, you know, remember I can't talk. And so I'm just like trying to keep my eye on that, and on a break, I'll go and say, what piece of paper was that? If you've got voluminous exhibits, bait stamp. If you think about that, when we are going to prepare an appeal and we have to scan all those documents, I don't really know if I missed one, you know, if their couple get fed into the scanner. If they're bait stamped, I know I can account for every one of those ahead of time. So that would be a great and appreciated thing. I will say Judge Perkins was not happy to have all of those boxes in his office because I had to keep them somewhere until, you know, I could finish the record.
Where's a good place to get a bait stamp?
Adobe does it.
Adobe.
Computer will do it now.
What software?
Adobe.
Oh, I don't think so. Oh. Okay, and I will tell you, if you're getting ready for trial, you're already thinking about what exhibits you're going to present, correct? You've probably given one to your co-counsel or your paralegal. If you have created a document that lists all the exhibits so that you can keep track, we would love it. And I mean love it if you would give us a copy of that too. If you think about it, you guys, Judge, I offer this, objection, blah, 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 admit it. Keep on going. I haven't had a chance to mark that it's been offered or that it's been admitted. But if I get a quick second, I can't write down what it is. It comes to us as it comes to us. So if you already have prepared a document as such, and I will say in family court, that's really not as big of a deal because usually there's not that many. But if you're in a murder trial or you're in a case that's going to be lasting a while, you could have hundreds of exhibits. So go ahead and give a copy of that to your court reporter. That would be great. Offering exhibits. Okay. Anybody ever had a court reporter chase you down and say, hey, you got my exhibit and I need it back? That happened to me when I came here. I won't say any names, but I was chasing a lawyer and she's like, well, that was not admitted. And I'm just like, I know, but you offered it. And so it is. It's only offered exhibits that from that point on, it becomes part of the record, okay? And that is the Texas Rules of Appellate Procedure 13.1b, that we're responsible for all offered exhibits. Ms. Koftia was talking about things that are for a limited purpose. Okay, so we don't care. We don't care if it's for demonstrative or a limited purpose. We do make a note of that, and certainly if it's for the record only, we guard that so that it doesn't go back to the jury. But yes, so if it's for a limited purpose, we're still going to keep them. It still goes with the record. In that situation that she had talked about, it was complicated because then if you're going to take an original exhibit, which is what it should have been, even I made a mistake, and I copied it from one to the next. And because that's what we normally do, we make sure that they have a copy of everything But in that particular instance, and she had brought it to my attention, wait, that was for a limited purpose. And because there was so much time between the time that I actually prepared it for her to review versus the time of the appeal. And there is a difference. We prepare things for you guys all the time, but we have different standards that we have to meet for the Court of Appeals. So just because we've prepared something for you all, we may include things that we like marked. Some people like to put where an exhibit is marked. The Court of Appeals, they want to know what's offered and what's admitted. So there's just some slight differences. Excuse me. So yes, so we abide by not only the Texas Rules of Appellate Procedure, we also have to adhere to the UFM, the Texas UFM. And that is basically the standards that tell us what our pitch has to be, how many lines per page, when a parenthetical, what the parenthetical has to say, how you identify speakers, how our index has to look like as far as exhibits and how they line up. It is our Bible, basically, that tells us what we have to do. And we also have the rules of the JCIT, the Judicial Committee on Information Technology. So let's move on to admitted exhibits. So when we first became reporters, you know, you pretty much just showed up with your machine and a power cord and some steno paper, exhibit stickers, but the advances in technology have just made it such that it is requiring more than the skill that we can use with our machines. We're now having to figure out the technology aspect of it, and it changes so fast. I mean, we have to get new machines because what we used to have as paper then moved to a floppy, and then that forces you to get another machine and different technology and change what you have or find something compatible so that in 10, 15 years we can still produce that record that we did on a floppy. I really do have computers still with floppy disks. It's crazy. But there's no more of that, and so we have to do everything, upload everything, and they're onto using the Thames portal. And I think you guys are familiar with that too. I mean, y'all use Thames as well, right? When you're filing your things with the Third Court of Appeals? Yes? No? No? Okay. Okay. So we have to figure out what the properties are of the admitted evidence. I will tell you that for videos, it has to be in an MP4 format is preferred. It's like the generic. It's the Hill Country Fair of evidence. We totally, it works for everybody, okay? For audio, for like your jail calls, just even anything that is just audio, MP3 is the preferred method. But, and that used to be the only two things that the third court would accept. Well, we would get things from convenience stores where they have like a proprietary software, or the Halo cameras downtown Austin. Those cannot be converted, by the way. It really became a challenge, and lawyers would come to court and just give it to us, and we're just like, okay, now what do we do? So truly, we have to search software and buy it, download it, and figure out how to use it so that we can convert that one piece of evidence to make it compatible to upload into the portal. Luckily, they have expanded that, so it's not has not become such a burden in recent times. But yeah, I already talked to you guys about the technology standards from the Judicial Committee on Information Technology. I think we're on the next slide. Okay, so we're going to go down to, we just took this excerpt that is number 3 on the digital media standards. I highlighted that everything has to be in a searchable PDF, so we call it OCR. Yes, using the OCR technology so that whatever we scan can be searched easily for the third court. And it makes it great for you guys as well. It talks about that we have to have it in 300 DPI. And honestly, that used to be a really difficult thing, but with the advances in technology, that's kind of, bare bones anymore. Most of your pictures, with smartphones and all that, 300 DPI used to be something pretty fancy, but it's nothing really that we have to worry about in these days. Audio and video. So the following media players are supported by specific audio video formats that can be found on each of these media players. We have the VLC media player and Windows media player, which I think is probably most acceptable, or most common. And you have to have one that is supported by either of those. Can we pull up the next one? Yeah, these are all the different formats that is supported by the VLC media player. And you would think that that is extensive, but there are others. And so we always have to go and kind of compare, is this one that they take? And that's why I'm saying MP4 and MP3, we love the Hill Country Fair version of audio and video because it really is the easiest to work with. Sometimes when things are too large, then we have to figure out how to slice it and put different copies, different sections. It's best if we just don't have to do that. And when you get it from APD as an example, if you're working with, has anybody ever had like a Sony camcorder? It comes with software that can convert it to other programs, and I'm just talking about MP4 right now. If you can get it on the front end, so that way the burden is not on you to convert it or not on me to convert it, it's much easier to do it at the original source. So that's what I would encourage you all to do to make it easier for all of us, quite frankly. And then on the Windows media, yeah, these are all the different versions. And these two versions I'm happy to send to anybody that, if you want to email me, I'm happy to send those two documents so that you'll have those for you. So I think most of the AVI and the WAV files, those are easy enough. Some of those others we don't really use very often, but again, like I said, the MP3 is probably the preferred way. I talked to you guys about the halo cameras downtown or dash cams. I don't know about Williamson County. APD, you cannot convert those. They have their own software inside of the CD when it comes to us. So we just have to copy it from one to the other, make sure that it's exactly the same size, make sure that it got completely transferred over before so that we can upload it. Gel phone calls, easy enough. Those are usually in MP3. Social media videos, not too bad. Surveillance videos, that gets sometimes to be a challenge. And if it gets to be too hard, if I don't feel confident in my ability to transfer it, I will just call and just say, hey, can I bring the original over because I'm struggling on this one. And usually the third court has been very gracious to let me do that, in which case I would get a court order for that. Exhibits, that bloody clothing, saint kits, guns, diagrams, those big kinds of things, obviously, they're not going to go through a scanner, so we have to either take pictures of them or we have a sheet that we will give the physical description of it and insert it in place of it. If they need to actually see it, then they will contact the clerk, and I think Amy will talk a little bit more about that. Okay? So I'm going to turn it over to Amy, and she's going to talk to you guys about what happens now. Like I said, Wilco is a little bit different,
Yeah.
so.
Can y'all hear me, or do I need a mic?
Take the mic.
Take the mic. Can you hear me now? Okay, I'm Amy Walker, and my boss is here, so this makes it even more difficult for me. But I don't like public speaking.
Everything I say every day.
That's why I'm a court reporter. I like to be seen and not heard. I feel like this might be a little payback for all the times I tell attorneys to speak up. So feel free to tell me to speak up. You know, it's my payback. I will be quick. Yeah, so that's another thing. I guess slow down, because I probably am going to be talking super fast to get this over with. And it's only about 5 minutes long. Basically, what I'm going to talk about is what happens once we receive the evidence after we've, you know, held you hostage in the courtroom until we get all our exhibits in. Basically, what happens, we, where's my little thing? We take it all back to our office, and then when we get a chance, we'll have to, you know, submit it to the clerk. So basically, this is just the Article 221 of the criminal procedure, and then we've got the civil that tells us we've got to go file it with the clerk. And I see an old clerk friend here, so that's sweet. So we, you know, we have two different forms we use. We have like a really simple one that's just, you know, if it's 1 or 2 exhibits. But sometimes when we're in trial, we'll type it all out so that it's really clear in the clerk's record what was filed, and you know, anybody that knows what kind of exhibit they need, you know, they'll be able to do that. So basically, the type of exhibits filed with the clerk, everything's filed with the clerk except firearms and contraband, and maybe anything that's dangerous, like could be a biohazard or something. And if we're in doubt, usually we ask our clerk, and she'll tell us, you know. And those we send to the sheriff's office, but the county clerk receives all the exhibits from civil, probate, misdemeanor cases in county courts. And then the district clerk receives the felony, the juvenile, and the civil cases that are in district court, and also all the family and CPS is filed in the district clerk's office. And so what happens at the clerk's office? I went and asked one of our clerks at my court, and basically we take the form to them and the exhibits. They make sure it's all there. They file stamp it, give us a copy, put it in an envelope, and then they have an exhibit clerk that actually takes the exhibits. They scan them out. I don't know if it's just for their records. I'm not sure that you can get a scanned version. You know, it would be convenient just to have it emailed to you. But then they go find a place in the attic and designate it, and make a little entry into Odyssey of who filed it and where it's located, so that if we need to retrieve it later. So exhibits that are firearms or contraband go to the sheriff's office. And this is interesting. We've always filed everything with the sheriff's office here because we were a county under 500,000. At our last census, it was like 427,000 or so. But now it's projected that we're about 550,000. So it should be going to, say Round Rock comes in a case, we should probably be calling Round Rock. And we're going to have to discuss that. It's just something that we've never had to do. Get with the sheriff's office and see how that's going to be handled. So that's the form we use when we have the sheriff come over. So basically we just call evidence, the crime scene people, and tell them we have evidence they need to come pick up after trial, and they'll come pick it up, and we'll kind of do the same thing that we do with the district clerk. We'll get a form for our records, and then we'll file that form usually with the clerk so that anybody looking will know where it is. So this was interesting because I don't have to retain exhibits. I file them, and so I asked our district clerk, and she gave me, that's what I say, good question, right? It depends on the case. She gave me this 100-page long retention record thing, and you know, I'm talking to a bunch of attorneys, and I'm not an attorney, so basically what I got from exhibits is, for civil exhibits, after the case is disposed of, it's generally 1 year. But then there seems to be a lot of other rules that I'm, you know, the if this, then that. So criminal exhibits, it says after the first anniversary of the date of the, when the conviction becomes final, if it's 1 year if it's a 5 years or less sentence, and it's 2 years if it's non-capital, but the sentence is greater than 5 years. So, and I'm not really sure, because they also have rules that you can't destroy any material that contains DNA, and there's all these other rules. So I don't know if any of them actually do get destroyed. But if they do, the clerk has to notify the state and the defendant's attorney before that happens. So that's kind of good to know. At least they won't do it without you knowing. And I tried to find out how that, I know the sheriff's office, they have a policy, it's under Chapter 18, which is another reason why I'm not a lawyer. But I do know that they have destruction records and that a judge has to sign off if anything's destroyed. So, so for that, the answer really is kind of good question. I don't know. And then the only other thing was when, say somebody needs a copy of an exhibit, whether it's an attorney or a reporter or the Court of Appeals. And like she was saying, the physical evidence, we don't send them, but say they want it. They'll contact the clerk, who will either, they'll do it themselves or refer it to the court reporter to go check out the exhibit. And then if a court reporter or attorney requests it, I just usually email the exhibit clerk, get the, go pick it up. They have a form to check it in and out. If an attorney wants an attorney that's an attorney of record, it's kind of a gray area, because I think some clerks will go ahead and get them a copy of it, but then I think it depends on the amount. So I think there's an attorney general opinion that says that the court reporters are responsible and that the clerks are the holders of it, so that we're supposed to come check it out and then provide it to the attorney. So you can always ask. So, and there's the form we have, so kind of exciting stuff. Okay, that's all. I didn't die. Does anybody have any questions? Or